Welcome, everybody. It's great to have you on board for our environmental due diligence of Rhode Island, done by our Rhode Island Commercial Appraisal Board. I'm Michael Sicoscio. I'm the current president of our board, and I'd like to thank our presenters today for their time and effort to put together a wonderful presentation. Especially a special thank you to Sage Environmental and Rick Mandwell for his sponsorship for our board events. So let's talk about Rick for a minute. Rick's bio is lengthy and a lot of experience. He's provided thousands of environmental assessments and all types of real estate on behalf of sellers, buyers, and lenders throughout New England and the East Coast. He holds an impressive 30-year career experience and success in the largest Rhode Island headquarters environmental firm since 1995, Sage Environmental, which was awarded the silver medal in 2020 by the Environmental Business Journal for their environmental business of the year. Rick is past chairman of the Environmental Business Council, member of the Rhode Island Society of Environmental Professionals, the American Council of Engineering Companies, Rhode Island chapter, and subcommittee member of Environmental Committee, the Licensed Site Professionals of Massachusetts, and a New Jersey Licensed Remediation Professionals Association. Rick, you've been busy.
I am.
I'd also like to thank Mike Donahan from Orson and Buccini, a local law firm. Mike oversees the firm Environmental's practice. He has over 30 years experience in environmental law. He's the author and editor of Rhode Island Environmental Handbook and is recognized by Martindale and Hubbard as a preeminent attorney in his field. Mike's practice involves advising clients on all matters of federal and state environmental permitting, compliance, remediation matters, including those related to corporate transaction, real estate, and renewable energy projects. He has extensive experience in all areas of environmental law, remediation with soil, groundwater, and natural resources, federal and state brownfields, site mediation and redevelopment matters involving hazardous waste and solid waste, at disposal of it, including water and air discharge, land use planning and development, freshwater and coastal wetlands, permitting and the development of energy projects, specifically including those before the Energy Facility Siting Board, and matters involving regulatory compliance, enforcement, and litigation. Another busy professional. Thank you, Michael, for your time today. So it's all yours, guys. So go to it.
Okay, hand over the screen and I'll here we go.
Rick, we can see you. It looks like you're on. You're on.
Can you see my screen?
Yep, I can.
Okay.
I see you, not the screen, Rick.
Oh, hold on. There we go. Sorry. There we go. How's that?
Perfect.
Sounds good. We can see
Okay.
the Sage logo and today's presentation
Okay.
and both of your names. So we're good to go.
All right, Michael, thank you for the intro.
No problem.
Yep, appreciate you guys having Mike Donegan and I back. We gave this first presentation a little over a year ago, and we've got some updates to it. Mike has a hard stop today at 5:30, so we're going to move quickly through the slides. We've got about 20 slides. If possible, you could either save your questions to the end, or you can write questions in the chat group, and we'll try to answer those at the end of the presentation. We're making the assumption that most of you on this presentation are relatively experienced in the commercial real estate sphere. So I don't want to dumb it down too much, if you know what I mean. So we're going to go through this quickly, and hopefully you guys have some good questions at the end. So for those of you who aren't familiar with environmental laws or liability, I'm going to hand this question over to Mike. He's the lawyer.
In the business at 8:25.
He can tell you
Um,
all about who's liable, and whoever's talking, please mute yourself. Thank
Yep,
you. Mike, talk about who's liable.
All right, are we on the, I think what we're seeing is the DEM. I think it's the next slide, isn't it?
Well, these are the regulatory agencies.
okay.
Yep. Who is
All right.
liable and why?
Yep.
That's DEM. And then here,
Sure.
there's the slide.
So oftentimes when Rick and I get involved, right, you have clients, we have clients who have a completely skewed idea of what liability is. Oftentimes we get people where our clients are willing to, they'll accept the risk because of some past experience, which may or may not be, relevant. They also don't always appreciate the subtleties of financing and the real liability schemes. And so we'll just run through quickly. Typically, what we, under the Rhode Island site remediation regs, the liability scheme we're most concerned about is for ground down contamination, soil and groundwater. And so it could be originating on site, or it could be entering your property from abutting sites, and you have the same liability scheme. So the liability scheme, the legal term is joint and several liability. And what that means is that each of you, if you are a defined responsible party, has, could someone mute whoever? So each of you, so each of you who has liability has the entire liability. So if you have a prior owner and you're the buyer, and the government decides to go after each of you or collectively, they can just decide ultimately to sue one of you and hold you completely responsible. What you win is the lawsuit against the other responsible parties. And the definition of responsible party includes owners and operators. So we have the current owner, past owners if they owned while the release occurred, current tenants. So this is a tough one. People think that if they become a tenant instead of owning it, oh, we're not in the chain of title, because they think that's relevant somehow. And it's actually not. If you're a tenant, you are a quote unquote operator. And now when they issue a notice of violation or an immediate compliance order, should they decide to litigate with you, they will litigate against whoever holds the deed, but also they have the right to litigate against the tenant, and they don't have to prove which of you did what. You are both equally liable for the remediation. A tenant who came in and all they ever did was write greeting cards has the same liability as the prior tenant who was a chemical company. So that's why it's important how your lease reads, that your landlord is viable, and that you do, most importantly, do your due diligence on the way in with Rick and your attorneys. The abutters impacting the property also have liability. One thing that might be valuable to understand as you go forward with your clients and engage in commercial transactions is that lenders can be skittish, as we know, but that the Rhode Island Industrial Property Remediation and Reuse Act specifically excludes lenders who foreclose and take the property. So unlike in some states, they have no liability even if they take the deed, so now they're the owner, or if they foreclose on just a leasehold and now they're the tenant. So they're protected anyway. It doesn't mean that the property, if they go to sell it, won't be diminished in value, right? So that's why they're concerned, but they have no liability. And that's a thing as you struggle to close these transactions that you can point to lender to, which typically helps some. When you're buying a business, you're selling real estate or buying real estate, be aware that there's a theory of liability where your company, your client buys the building with an ongoing business, and the argument is whatever the business did that was prior to this new business, let's say they're buying the assets, that they're a continuing enterprise. So you always have to look at this. If your client is buying the real estate and the business assets of a seller, if they're going to operate and sell the same things and use the trade name and in all respects or most respects look like they're the same company, then they will inherit the liability. DEM, of course, has enforcement discretion to come after any one of the responsible parties or all of them. And they often go after the title owner and then the tenant in that order before they start spending their resources going back at prior owners, abutters, all of that. When the DEM encounters a challenging litigation matter, so let's say we are collectively representing someone they send a notice of violation to, and the remediation could be very expensive, so we're not doing it, and it could impact, say, a drinking water source or a sensitive receptor. The EPA always retains the ability to refer, the DEM always retains the ability to refer to the EPA. At that point, we all collectively have a very different discussion. Managing DEM with its limited resources and having our experience with DEM is very different than having the EPA involved, because they bring in the Department of Justice as their attorneys. No budget, they will litigate till the cows come home, and that's a very different issue. So we typically manage it so it doesn't go that way. When private parties litigate, let's say we have to go, someone comes after us, we bought land and our property is the source of a groundwater plume leaving the site, entering someone else's property. They can sue under various statutes that give citizens a right to sue. They can also sue you at common law. And of course, should there ever be a contractual indemnity, that exists as well. It's important to understand that some statutory rights exist under the Industrial Property Remediation and Reuse Act, which we call the Brownfield Statute. So there are liabilities and rights under that statute. That law gives the DEM the authority to create the site remediation regulations and enforce that way. But we also have the Rhode Island Clean Water Act, the Refuse Disposal Act dealing with solid waste. And each of these statutes, oddly, creates different liability obligations. So under the Clean Water Act, you can, if you incur remediation costs for groundwater, you can sue any person who's responsible. Solid waste has yet a different one. We even have different reporting obligations, and we can talk about that a little later. Common law claims that you may see if for you look at with your client is if you're buying a piece of real estate and an abutter is contaminating it, there are also trespass claims, nuisance claims, things you're probably very familiar with. So 30,000 feet, that's the liability scheme.
Okay, thanks, Mike. So you folks as realtors or appraisers are probably asking yourself, why does any of this matter to me? Well, you guys have a certain duty to disclose, and a lot of folks on this call are relatively savvy when it comes to environmental issues and liabilities associated with real estate. So we all know that, and I'm sure you've had experience in your careers, that there are environmental issues that can crop up, then kill your deals, right? So we're hopefully, you're going to learn something here today that enables you to get through those deal killers sooner in the process, saving you time and money. And really, at the end of the day, what our recommendation is always get your real estate or get your client's real estate house in order. And what does that mean? It means make sure you have a good, clean, updated phase 1 environmental site assessment before you go to market. Don't hand that responsibility off to a prospective buyer, right? Because they're going to use that against your seller as leverage to say, oh, you've got all these environmental issues. It's going to slow your deal down. It's going to cost time and money. So again, just generally speaking, you want to get your client's real estate house in order prior to going to market. Phase one environmental site assessments, for those of you who don't know, which I would be surprised that you don't, they are sort of the coin of the realm when it comes to environmental due diligence. It's the first thing that we do prior to prior to going to market. We have a standard. It's a nationally recognized standard by the ASTM. The EPA also recognizes this ASTM phase one standard. And essentially what a phase one is attempting to do is it's attempting to tell a story or the history of the environmental use of a piece of real estate as it relates to whether or not there may have been any historic uses or even current uses that are causing contamination to exist at or to a property. And I emphasize the to a property, reflecting on what Mike had said a little earlier about you can have a client who owns a piece of property that's being contaminated or impacted by an upgradient offsite source. But because your client is the title holder of record on that property that's being contaminated by an upgradient offsite source, technically, they are responsible under the liability schemes here in Rhode Island to deal with that contamination issue. So again, you want to do a phase one early, make sure it's updated, get it done by a reputable local firm. And I emphasize local because we see out-of-state firms come in and they just don't have the knowledge or the historic access to a lot of the resources that we have here in Rhode Island. And just to give you a little statistic, over the last 30 years of doing environmental assessments here in Rhode Island and elsewhere in New England, we've done close to 5,000 sites in the area, many of which we've had to do multiple times over the years. So it's that record and knowledge that is going to benefit you and your clients in the future. So go local, as the saying says. I'm going to talk a little bit about what the ASTM standard talks about. You'll hear these terms: RECs, PECs, HRECs, CRECs, data gaps. Those are terms that are part of the standard. RECs meaning recognized environmental conditions. That's something that's in a phase one. Essentially, a REC in layman's terms means, hey, there's a potential release or a threat of a release of oil or hazardous materials at or to this property. So there's an issue that's been raised in a phase one that says, hey, we think you need to do more assessment to try to figure out if this REC or data gap is significant enough that it's causing some contamination to a property. In what's known as transaction screen reports, which are basically abbreviated phase ones, those are potential environmental concerns, or PECs. Kind of similar to a data gap, kind of similar to a REC, something that needs to be further assessed, whether it be through more research or actual testing or ground penetrating radar or drain testing, that sort of thing. Something beyond a phase one or a transaction screen needs to be further assessed. An HREC is a historic recognized condition, meaning, hey, there was an environmental issue at some point in the past on this property, but it's been addressed and it's no longer a significant issue. And a CREC is a controlled environmental issue. So here in Rhode Island, a classic example of a controlled REC would be a site that has gone through the DEM regulatory process and it's come out the other end with an administrative closure by DEM in the form of a letter of compliance or no further action, where that controlled environmental condition is being controlled by a cap. And we'll talk a little bit about caps in a couple of slides, but caps are parking lots, building footprints, landscaped areas, whereby DEM will allow contamination to remain beneath a property so long as it's being controlled with a cap in some form, and an environmental land use restriction is placed against that same property, and it requires that that cap be maintained annually, inspected, and a report sent into DEM. There's literally been close to 1,000 sites here in Rhode Island that have been capped with ELURs on them, and we'll talk a little bit later on those stats. Emerging contaminants of concern. I would imagine that you folks have heard about this thing called PFAS or PFOS. We've been dealing with this contaminant now from a regulated perspective for almost 10 years, initially by EPA, but most recently, as of December of 2023, the DEM adopted new PFAS standards for groundwater, GA groundwater resource areas, and surface water bodies. So you can imagine, we have a lot of surface water in Rhode Island, right? So from an applicability standpoint, we now have these new PFAS standards that are the first contaminant that's being regulated at the part per trillion level. Up until PFAS, things were being regulated at the part per million and part per billion level. PFAS has taken us an order of magnitude deeper in that we're regulating things at the PPT level. And it's a real challenge for us in the environmental consulting world, but also on the regulated front. DEM is struggling now that we're surfacing these sites that have these PFAS contaminants on them. You know, we're all kind of scratching our head. How do we cost effectively deal with them? So stay tuned. If you have questions, Mike, go ahead.
Yeah, I was just going to jump in. Two things. One, takeaway on the first bullet point that Rick was discussing, which is this ASTM standard. It's a standard site assessment everywhere. That's what your lenders will require. And if you have a recognized environmental condition, the protocol requires the consultant to recommend a phase 2. So you must do phase groundwater and soil. And so your clients may be like, hey, I'll hire this other consultant. I won't say that, or, you know, like that has been eliminated. And so it's standard, and it's what your bank's going to look to. So if there's a rec, there's going to be that conclusion. It's a binary recommendation. It's either thumbs up, there are no recs, you don't have to do any more work, or thumbs down, there are recs, in which case you must do a phase 2. That'll drive lending decisions and timing. The second thing is when you look at PFAS, I'll give you an example. So you're reading about it in the papers all the time as the forever chemical, and it's in our drinking water, right? It's everywhere. And so I represent Warwick and South Kingstown and University of Rhode Island, all public water supply systems and others, in litigation to recover the tremendous costs of compliance, up to 20 million for one of my clients at capital costs and then O&M. But the reason where you're going to find it is, you know, you may have clients who are buyers who ask, is the water, does it have this in it, and what do you do about it? The answer is you can know that because every community in Rhode Island was required to test it, and the Rhode Island Department of Health website will allow you to go check it. But if you do have a hit, you know, Rick and company, it's just a carbon filtration solution. So you can do it and make it work for your client's employees, residents, if it's, you know, whatever. So it's top of mind for many people who read the news and who buy and develop real estate, but the solution is relatively easy. So that shouldn't, you know, create any problem in your deals. And a real life example that I just had was a seller is selling an auto dealership. My client bought it. And turns out that even though public water was available, they were using an on-site well. Auto dealerships use all kinds of products that contain PFAS, and the drinking well was highly contaminated. It meant that we had to not only put it on public water, but now if there are septic systems, do you chase it? There's a stream. Does the stream lead to the reservoir? Yes to all those things. So you can see how that would be require a very sophisticated response as a buyer, how we're going to handle that. We're able to work through it all, but those are all things that you may see come up.
Thanks for that, Mike. And for those of you that don't know, the reason I have the little firefighter here with the foam spray, that's what PFAS is most commonly associated with. It's those firefighting foams that have the surfactant PFAS within them. Great for putting out fires, not so great for cancer. So PFAS, it's a real issue these days. So here is just an outline of DEM's site remediation regulatory process and the documentation that goes back and forth through it. And we talk about a site investigation report you see there, the third bullet down. That is essentially a phase 1 and a phase 2 combined, where we're assessing a property's history as well as testing soil and groundwater. And then you go through this document process all the way through remediation if needed, and eventually site closure. And the outcome hopefully is a letter of compliance there at the end. DEM's been issuing letters of compliance now for over 25 years. The lending community is very familiar with them. They lend around them all the time.
Rick, I would just say that in when you encounter property where you represent a buyer or a seller, and there's what we call an environmental land usage restriction. It's a deed restriction from that you negotiate with DEM that commonly says, don't drink the water, don't maintain the parking lot, inspect it every year as a cap. If you dig below, the cap or 2 feet, you have to have a soils management plan, those kinds of things. And it may say no residential use, no daycares, no, that kind of thing. You should know that all of that can be changed. That if you want to buy a place with a deed restriction on it that says you can't do residential, we can get it residential. Okay, it just wasn't proposed then, and there's a process that you have to go through. So anyway, I just wanted to add that.
Mike, this next slide, right? I think we talked about, who has, who's liable, who's has reporting. Let me go to this next one here. So why don't you talk about remedial agreements, Mike, here in Rhode?
Right. So when you're buying commercial properties, since we know that if you buy it and there's some contamination, you often find buyers and sellers negotiate a price discount and then the buyer will handle it, or you have to remediate it before I close, or we have to have some combination, maybe we meet in the middle. There has to be an approved work plan so we know what the cost will be, and we have to have a discount. What's important to understand is there are protections available to buyers and tenants. So when you look at, when your tenant, especially big ones, are going to rent commercial space, there is never a reason not to have what we call a remedial agreement, which is commonly called a brownfields agreement. What it does is it basically is the government signs an agreement saying that you, the tenant, have the prospective tenant, as long as you sign this, very short certification that says you didn't contaminate the property and you're not an owner or operator, nor are you a past owner operator, and you don't own a percentage of the seller or the property owner, they will sign an agreement that says you will not be held liable for the contamination on site. So I would always do that to the extent that there's any contamination, past or present, identified as a tenant. When it comes to buying property and there's any contamination identified, you can go and do the same as an owner. I'm going to buy the property. You tell the DEM, you give them a document that evidences is a real deal, and then you execute an agreement. And typically it says that there has been remediation done, that you will agree to maintain the parking lot and inspect it every year, that you will agree to abide by the environmental land use restriction. And if you do those things, we will not hold you liable for any of that identified contamination. The good news is that gets recorded and it travels with the land so long as paragraph 7 is before a person buys it, they have to notify DEM and tell them we're going to be a new owner and we agree to abide by the conditions. And then the DEM says, great, you inherit the agreement with all its benefits. Those, having a remedial agreement for a tenant who may borrow money for improvements or to expand or use collateral as the lease as collateral, or having someone borrow money that's going to use the land as collateral, having a get out of jail free card in the form of a remedial agreement, even if no money changed hands, is always a good idea.
All right, thanks for that, Mike. This next slide, and Mike will talk a little bit more about it, but if there's one thing you take away from our conversation here today, it's this next slide, the attorney-client privilege as it relates to environmental assessment of a property. So a lot of buyers and sellers are very nervous about having any environmental testing done on a piece of real estate that they own or want to buy. And right, they're nervous about that because of those reporting obligations and those liabilities that Mike talked about earlier. So the way that we've been dealing with that concern, which is a very real concern, right? A property owner or a tenant, when they get knowledge or have knowledge of a release through any testing, the rules and regs say, hey, you got to report that within 15 days of that knowledge. Well, the way we, for lack of a better term, avoid that is I and my other consulting brethren, we are oftentimes hired by outside third-party legal counsel, somebody like Mike. So Mike would hire us to do that soil and or groundwater testing, and affords the buyer or seller, in the case, of having a potential reporting obligation. Sort of think of it as a free peek, if you will. So this is a way to get your buyers and sellers comfortable in doing that environmental due diligence without running into a reporting obligation. I don't know, Mike, if you wanted to expound on that
Yeah,
at all.
sure. So typically this comes up, you have a common buy-sell agreement, and if the seller will let you the buyer do testing, they do soil and groundwater testing, they're concerned, right, that you're going to go to the DEM, drop the data on them. It's a big remedial obligation and you walk away. They want to avoid that. So when they let the buyer do the environmental testing, you often sign some confidentiality agreement, or there's a provision in the purchase agreement that says you will disclose none of this, right? Which you agree to because you want to take a look and know. So we get we can give further comfort when I represent buyers in that I can tell the seller, and it helps my client, the buyer, as well. I will retain Sage Environmental to assist me in rendering legal advice to my client. Think a tax lawyer hiring an accounting firm to help it evaluate compliance or non-compliance. And so what I do is I have my clients agree that here's what's going to be spent. I talk through what it is, and they agree. I hire Sage. Sage goes out and does the scope of investigation agreed upon. And when they get the data, it comes to me. We can even attenuate it further by having Sage pick a lab that it does so much work with that they will call Sage up and give them a verbal before they ever even print laboratory certificates that have data. If we get the numbers back and Sage's advice is this is a multi-million-dollar or problem or one that's bigger than the deal's worth, then we can just go home. Or if it turns out that we want to work it into the deal, we can go back and approach the seller's counsel and say, look, we have issues here that would need to be worked into the deal. Would you like to talk about them? And again, I do it directly with the lawyer. We talk about it. Because my client has never received the data, they wouldn't have a reporting obligation even if they owned the property. So that's the argument. they don't own the property. And remember, only owners and operators have a reporting obligation. It tracks the liability. So because they aren't a responsible party as defined, your buyer has no obligation even if they knew, but I'm trying to protect them for if they do close. So that's kind of how that works. How good is the shield? Well, the protection is that we want to encourage lawyers to represent their clients fully and zealously. And so if that's assisting me, it's protected. But really what's protected is my advice. So to the extent that there is a fact like a laboratory certificate that's in my client's hands, in theory, they have to turn that over. And think of it this way. I'm your lawyer, you invite me to your facility, I walk in and there's a dead body. Okay? I can tell you run or call the police. That's my legal advice. That's protected. But if somebody subpoenaed me in court and asked me to answer a question, did you see a body? That's a fact. So that's not protected. But I will tell you that in my many years of practice, I do just this work. There has never been a case where a court or any agency has pierced the veil to make a lawyer disclose any of that, nor have they held a client responsible. So this is a common technique. It's done better and worse depending upon how you understand the nuances, but it's another way to move the deal forward when you think you're at impasse.
Thanks, Mike. I mentioned earlier, right, the environmental rules and regs. A lot of folks think that, oh, I've got to clean a property up to pre-Columbian or pristine conditions. That is not the case. Our environmental regulations have evolved over the years as we've learned more about human toxicology, and our regs reflect that. So DEM, we're allowed to leave a lot of contamination beneath properties so long as they are being maintained on a property in such a way that they're not migrating off-site and impacting other properties, surrounding properties, and or they're not, the contamination that's being contained on site isn't harming humans or allowing them to get in, to come in contact with it. And as you can see here, you see this building here, this is related to subslab soil gas vapor intrusion. It's a big issue in our world nowadays where the ASTM standard is driving us on the consulting side of things to evaluate properties for their potential for these subslab soil gases to get in and contaminate the indoor air in a property. So again, very common that we're capping contamination in place. And I'm going to show you a slide next. This slide I just updated with Kelly Owens. She runs DEM site remediation regulatory process. You can see right here, they got about 1,000 active sites right now in DEM. They only have 6 full-time staffers. 4 of them are relatively experienced. They've got 2 newbies. Letters of compliance, in other words, sites that have gone all the way through the assessment and remediation process in Rhode Island, almost 800 sites to date. Interim letters of compliance, in other words, sites that have gone through the site remediation process and they may be in a long-term monitoring mode or a long-term cleanup mode where the letter of compliance is conditioned on them completing that remediation. Once they do, they get rid of the interim and it becomes a letter of compliance site, an LOC site. No further action sites. Those are more often than not associated with leaking underground storage tank sites. And that's a turn of phrase, if you will. That's what the leaking underground storage tank program uses. There's over 400 of those. And of the sites that are closed with LOCs, ILOCs, or no further actions, 98% of those sites have some form of capping as a remedial solution on that site. So again, just because the site's contaminated doesn't mean it's necessarily a deal killer. And more often than not, DM will allow us to cap those sites in place. I'm going to skip the next slide. I don't think there's a lot of value there. for those of you who are familiar with home inspections, right? Right, we've all had them. In the commercial and industrial world, we have home inspections. Essentially, they're called property condition assessments. Same thing. It's looking at a commercial or industrial building's mechanical systems. This is an example of what we look at, right? Looking at superstructure, facades, roof, basement, attic, ADA compliance, windows, interior finishes, HVAC, electrical. So, right, your environmental due diligence oftentimes isn't just ground down. In other words, what's under your feet, but it also oftentimes will include what might be ground up or in a building or a building envelope that will have environmental conditions or issues to be assessed, asbestos, lead, PCBs, those types of things that might be found in building products. Get through that. Mike and I hear this all the time. Oh, DEM, Rhode Island, they're unreasonable. Trust us. We work throughout New England. The DEM's regulations and the environmental professionals in the department that are charged with implementing them, we have it great here in Rhode Island compared to other states. Mike and I, we have on speed dial Terry Gray, the DEM director, Susan Forsey, the assistant director, and all of their staff in the various programs. We can get on a call at any moment and talk through in a hypothetical manner a particular site's conditions, and we can usually get a pretty good idea about how a site might fall within the DEM regulatory programs to advise you and your clients, hey, is this a site that we can kind of work through on the regulatory side, or are conditions such that it's a deal killer? So again, when you hear people complain about DEM's rules and regs, please push back. We do have it good here.
Right, and I'll just say that, Rick and I have worked on redeveloping, say, Kettle Point, right? Former oil terminals. We're working on Chevron's oil terminal, working on, Unical's. We're, on the port in Providence, we've worked on, petroleum facility transfers all in the water. And we don't have a process that says 15 days, the DEM will do this, 30 days later, they'll do that. It's not set up like some states. But what really happens is they'll jump through hoops to help us if there is a transaction deadline. They really will. They will, and we can get that what's called a bona fide prospective purchaser certificate that I mentioned, which is the first step. You get that before you close, and you do the remedial grant post closing. We could get that in a day if we needed it.
Right.
And so they really do work with us, and I think that's top down. So
It is.
I think we do have it lucky here.
Yeah. Yeah, Mike, I like to say to clients and friends, we've made a lot of deposits in the DEM Goodwill Bank account, and our clients will call us to draw on those accounts, and it's been a very, very beneficial relationship that we've had over the decades. We've got about 10 minutes left. I am going to now open it up for questions, comments, thoughts to the audience.
And by the way, that's a picture of Rick, not me.
Rick, Mike, I'll start with a question. Mike Sakosio. I was listening to one of the talk shows about the bridge that's going to need repairs. And one of the things that came up would be environmental issues when they start to work around the piers. Who would be responsible for that? And maybe you can talk a little bit about that, because you said you've been working regularly in the bay. How will that unfold, and how is that capped at, if there's contaminants in the soil?
Good question, Mike. As a matter of fact, we have been working with the Rhode Island Department of Transportation actually long before the bridge, but oftentimes bridges in the state, they have joint compound where pieces of bridges will meet. And that joint compound oftentimes will contain high levels of PCBs. The PCB oil is actually used to keep glues and mastics
The
flexible.
binding
So
agent?
it's not a binding agent per se, but it's like a caulk joint.
Okay,
So what the DOT will do is they will have a survey done where we'll go out and we'll collect samples from that joint compound. And if there is PCBs in it, that we'll have to remediate. If there's a small amount, we'll remove that joint compound first. If there's a large amount, it may not make economic sense to try to tease that stuff out. But my expectation is there's going to be some amount of PCB containing joint compound. And then what they will likely do, and we've been in conversations with DOT in the state, they will likely grind the uncontaminated concrete up on the bridge, remove the rebar that's in it, and they will likely beneficially reuse that concrete, crush it down to say 3" minus in size, something the size of your fist or smaller. And we will likely use that as part of a redevelopment effort somewhere in the state. That's typically known as a beneficial use determination or a BUD. And we actually have a big BUD site just downstream or downriver from the bridge at South Key, which Mike and I recently got a BUD from DEM to allow using that type of crushed bridge material, so long as it's clean, as fill on a site like that.
Right, and that's what you guys may have read, that we're working on an offshore wind port to service all the new farms that are coming online. They need staging areas, they need to ship things in from Europe and all of that. And that's the South Providence sticking into the river. You probably see it right near Tockwatton, kind of the Wilkes-Barre Pier, that whole area that just looks undeveloped out there, that acreage. And so that has to be brought up to 7 feet. How big we have? How much we have to bring that up?
Yeah, it's going to be somewhere between 5 and 7. I think it's going to be more because it's going to settle over time.
So anyway, that's what's going to happen if all goes well with some of the clean bridge material. But the contractor who does it, when the DOT bids it out, they are obligated contractually to assess it all and manage it all properly and protect against it falling in the water and all of that.
Other
Guys, I have
questions?
another question. If I list a property that's a typical dramatic building, like a gas station, dry cleaner, a heavy mechanic site, plating company, can we skip the phase 1 and go right to a phase 2? Or is that the phase 1 still part of the phase 2? Can you comment on that?
You can skip the phase 1, but I wouldn't, because the phase
Okay.
1 informs you where you need to put your borings and wells, right? It gives you
Okay.
all of that historic site use that may not be readily apparent today when we go out and look at a site, right? I mean, we live in the oldest developed real estate in the country. We've got multiple generations on top of sites, right? So what I see out there today might have looked very different 50 or 100 years ago. So I wouldn't skip a phase 1.
And it's cheap. And to put some specifics to it, like if there was a tank that was closed, and you can't tell that when you go out there, the records review might tell you if there's a dry well, if there was, any anomalous site condition, a sinkhole, anything at all. Like, you want to get the best information from the records review to tell you where to go and look, so that you.
I recently read the whole one, and I was amazed on the data in a phase 1. It's luminous. It's volumes and public record work. I mean, you earn your pay on that one.
Yeah.
I have one more
and it
wrap
comes
up.
with, Mike, and it also comes with the most amount of liability to me as a
I
consultant.
hear you. My dad's an architect, and I talked to him one time, and he said, our liability is catastrophic. He says, because we don't, like a doctor could only kill one. We could hit hundreds of thousands by having an inferior design.
Yep.
I guess I have one final question, because it's none coming from the group, so I might as well quiz you, and respect Mike's time to be a hard stop in a few minutes. But I'm involved in a project that we had to have a HUD environmental assessment. Appears to be a more different documentation.
Yep.
Maybe you can explain to our audience what the difference is on that.
I'm doing one right now. I don't know, Rick, if you want to do it from the consultant side, or I can talk about the process, however you want to do it.
Mike,
Yeah,
why don't you
well-
start first so we can respect your time? How's that?
Yeah,
Sure.
Mike.
So the one I'm working on right now, right, there are typical lenders who package these things up for HUD. HUD has very specific requirements, and they are relatively inflexible, right? So by
Mike, not to interrupt, but one of the things that our audience might not know is you can't enter into an agreement without having this environmental done when there's any
yeah,
financing, correct?
that's exactly right. And
Sorry
so
to rain on your parade.
yeah. So yeah, one of the issues is when their consultant reviewed the environmental data, the recommendation to HUD is that you have to have it remediated and have in your possession a letter of compliance. So the site has to be closed, but the financing, you have a term sheet, right? It's only locked for a period of time. And what's really happening is just to get through this process is going to take you a year. So they required that. They also identified that there was flooding in the basement, and that needed to be, the source had to be identified and corrected before closing. Like the conditions that they came forward with were absolutely couldn't happen in any meaningful time frame. We can do it all. It's not even going to be that expensive. It's just time. And so the client that I have who does this and owns several HUD properties, what he's now does is gets it all ready in advance, meets with the same consulting firm that works with the same lender they use, and they just go through it all to get them prepped. So they're always ready when the interest rate climate is good or their need dictates.
And from my side of it, right, it's housing, right? So the HUD environmental due diligence goes above and beyond, Mike, to your point, what a normal ASTM phase one might entail. They typically want soil testing, superficial soil testing around where they're going to lend on this housing development. They'll oftentimes want us to do some, if it's existing housing stock, they oftentimes will want us to do some type of indoor air quality assessment as part of it. So it's definitely more than a phase one. And they're oftentimes needed to be updated.
Yep, and I'll just throw out there the dilemma you face as the owner, which is when you go to get your financing and they now require you to do all of this work. If you decide you're not going to do it and you disclose to them the conditions, query whether you are in default under your existing loan that you're trying to refinance, subject to having them call it. So it's just that again goes back to do it in a privileged way and don't give them the information until you've made a decision.
Good, Mike, I thank you very much. I know it's just at 5:30, so I think we can close this session up, and thank you both. It's really been enlightening, especially the part about client privilege, to make sure that you have that attorney order that inspection and keep those results under client privilege. Just that one fact alone is worth this whole session. So,
Sure. And
again,
Mike,
thank you, guys.
Mike, I'd like to extend to the group that if, Rick and I live in this community, and you can call us up and ask us a question or float something by us. We don't have to open a file and bill you. We're just happy to, build the relationships and just, whatever's on your desk. If you have a confusing question, please feel free to reach out anytime.
Right.
I appreciate that courtesy, gentlemen. Thank you.
Okay. All right. Take care.
All right. Have
Thanks,
a good
guys.
evening, everyone, and thanks for your participation.
Yep. Bye.